The Senate will please come to order. It's my pleasure to introduce for today's devotional exercise, the Reverend Kenzin of the Shaoshan Temple of East Calais.
As we see the simple, cloudless blue sky above our beautiful state of Vermont, may it inspire us to pause, to take time to notice and appreciate the simple miracle of our own breath and the exuberant miracle of spring. As we see the vast open sky above our beautiful state of Vermont, visible for all and stretching in all directions. An expansive sky encompassing the entire planet. May we recognize our commonality with one another and our interconnection with all life. As we see the crystal clear blue sky above our beautiful state of Vermont, with a clarity perhaps like our original clear aspiration to public service, our original intention to be of help. And although clouds may obscure the blue sky for minutes, days, or seemingly endlessly, yet beyond the clouds, the clarity remains. So too, if complexities cloud over and discourage, may we remember our simple original aspiration of public service, clear and shining. Jiho san shi shi fu shi san bu sa mo ko sa mo ko ja oro mi.
Thank you. I'll now kindly ask that you stand for the Pledge of Allegiance. I pledge of allegiance
Pledge allegiance
to the flag
to the flag
of the United
of
States
the
of
United
America
States of America,
and to the republic for which it stands,
stands
one nation,
nation,
under
under
God,
God,
indivisible,
indivisible,
with liberty
liberty
and
and justice
for all.
Are there any announcements this morning? We have a House bill under Rule 31 being on the calendar for notice and affecting the expenditures of the state under Rule 31 is referred to the Committee on Appropriations, H81. We have a Senate resolution to take up at this time. JRS 20 relating to weekend adjournments. Please listen to the reading of the resolution.
JRS 20, joint resolution relating to weekend adjournment. Resolved by the Senate and House of Representatives that when the two houses adjourn on Friday, March 26, 2021, it be to meet again no later than Tuesday, March 30, 2021.
Now you've heard the reading of the resolution. The question is, shall the Senate adopt the resolution on its part? Are you ready for the question? And if so, please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've adopted the resolution. We have 4 House bills to take up this morning. H87, an act relating to establishing a classification system for criminal offenses, introduced in the House on January 19, 2021. Please listen to the first reading of the bill.
H87, an act relating to establishing a classification system for criminal offenses.
Now, the bill has been read for the first time and is referred to the Committee on Judiciary. H145, an act relating to amending the standards for law enforcement use of force, introduced in the House on January 28, 2021. Please listen to the first reading of the bill.
H145, an act relating to amending the standards for law enforcement use of force.
You've heard the first reading, and the bill is referred to the Committee on Judiciary. H154, an act relating to the failure of municipal officers to accept office, introduced in the House on January 29th, 2021. Please listen to the first reading.
H154, an act relating to the failure of municipal officers to accept office.
You've heard the first reading, and the bill is referred to the Committee on Government Operations. And finally, H428, an act relating to hate-motivated crimes and misconduct, introduced in the House on March 12, 2021. Please listen to the first reading of the bill.
H428, an act relating to hate-motivated crimes and misconduct.
You've heard the first reading, and the bill is referred to the Committee on Judiciary. This brings us to the orders of the day. We have on the calendar for action S3, introduced on January 12th. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 701 to 707 of today's calendar, and that when so amended, the bill ought to pass. The bill was then referred to the Committee on Appropriations, which reports that the bill should be amended as recommended by the Committee on Judiciary, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S3, an act relating to competency to stand trial and insanity as a defense.
The senator from Bennington, Senator Sears, is recognized for the report of the Committee on Judiciary.
Thank you, Madam President. We took a lot of testimony on S3, even though it's a familiar bill. S3 contains a number of provisions related to the court proceedings that occur in criminal cases when there are issues concerning either the defendant's sanity at the time of the offense was committed or the defendant's competency to stand trial for the offense. This bill will probably seem familiar to everyone who was here last year because most of the bill already passed the Senate in what was last time S183. However, passage of the bill was interrupted by COVID-19, so it's back again as S3. I want to first say that the genesis of last year's bill and this bill are cases that occurred dealing with mental health issues in Chittenden County. There were 3 murders that are probably fairly high profile where the state attorney dismissed them and the governor and the attorney general has now stepped in, I think, on all 3, if I'm correct. So that was the original genesis of the bill, to look at the issue of competency to stand trial. The first concept to understand about S3 is that while the insanity defense and defendant's competency to stand trial both concern a defendant's mental health status in connection with a criminal offense, the two concepts are very different. The insanity defense concerns the defendant's mental health status at the time the offense was committed. A person is not guilty by reason of insanity if, as a result of the mental illness, the person either cannot understand that his or her conduct is criminal or cannot conform his or her conduct to the requirements of the law. A defendant's competency to stand trial, on the other hand, concerns the defendant's mental health status at the time of the trial. A defendant is incompetent to stand trial if he or she is unable to understand the criminal charges or is unable to participate meaningfully in his or her own defense. It's a complete defense if a person is found not guilty by reason of insanity. The person is then not guilty and cannot be charged with a crime again. A person found incompetent to stand trial, however, can be recharged with a crime later after that person regains competency. As your committee was working on S3, Madam President, there was a horrid murder in Bennington on what's known as the River Walk. It is between the Bank of Bennington and the senior housing facility, where a nurse was visiting the senior housing facility, went to her car, which was parked in the Bank of Bennington parking lot because it was Martin Luther King's birthday holiday. The bank was not open. And she witnessed a young man acting very strangely, and she recognized that, and a young woman was walking on the Riverwalk and was murdered in broad daylight at around 11:15 a.m. that morning by this person. And she called the case in, and so rescue squad and et cetera were there very quickly, but unable to revive the victim. During that discussion, or after that murder, I heard loud and clear from our state's attorney, Erica Mathich, about some of the problems with the public safety aspect of the system that can be described as a forensic system in Vermont, that we don't have one, that it's inadequate. I'd like to read a few words from an email from her, if I might.
Without objection, you may.
Good morning. I just need to take this opportunity to express my extreme frustration with the disconnect between public safety and mental health. A disconnect that has only widened over the last 5 years. Even though the state's attorneys are responsible for safeguarding the public safety, we are excluded from receiving information or being part of the decision-making process for the mentally ill population with criminal involvement. It's been made clear to me that the Department of Mental Health is not responsible for public safety. In that case, the statute should allow the departments that are responsible for public safety to do their jobs and make decisions regarding risk. Emily's mother is on a mission, and she should be. The Emily Hammeran case highlights these significant issues. A brief snapshot of the history that I'm aware of, because despite my responsibility to the public protection, I'm not entitled to information in the possession of DMH. Her killer, Darren Pronto, was charged with false information to a police officer in February 2015, sent to a reparative board, which he completed in July of 2015. A few months later, in October, he was charged with domestic assault and placed on probation with mental health condition in February of 2016. He was supposed to work with a local designated agency, and the designated agency, of course, does not share information with the state's attorney. In any case, it's not just this one. Within months, he violated his probation and was brought back to given stricter probation. A year later, he violates his probation. Again, he's placed on probation, mental health conditions that require him to work with a designated mental health agency. He violates again within a month, and now his defense attorneys start to argue competency. During 2018, he's admitted to the state hospital, and the Department of Mental Health is entered as a party in the criminal proceedings. The state's attorney's office does not receive any information from the Department of Mental Health. In fact, we're told we're not entitled to the information. We cannot tell his victim at the time anything about the whereabouts. The defendant is found not competent, and the state attorney's office requests a hospitalization hearing, and the Department of Mental Health intervenes as a party. Here's where my main frustration comes in. The Department of Mental Health is not recommending hospitalization. The Department of Mental Health controls only the potential witnesses, the doctors at the hospital, and the state's attorneys are not entitled to any of the information from the state hospital. We have nothing to offer to support an order of hospitalization and need to withdraw our request. As we know from above, an order requiring him to work with the local designated agency has no value for him and has not prevented further criminal activity. A lot of the changes that you see in S3 are a result of that particular case. Not that it's good policy to make law based on a case, but it does highlight the lack of information. I should also mention, Madam President, that the vast, vast majority of people suffering from mental health do not commit crime. We are only talking about a small, very small subset that in most states is referred to as a forensic population, and we'll get to that in a minute as I walk through the bill. The current law describes in great detail the court procedures related to the insanity defense and competency to stand trial. S3 proposes several amendments to those procedures. Section 1 deals with a psychiatric examination that must occur when the question of the defendant's sanity or competency has been raised. The wording, the person either cannot understand his or her conduct or criminal cannot conform. The wording, the person is not guilty. The wording of the current statute requires that examinations evaluate both the defendant's competency and the defendant's sanity. Since competency and sanity are two different questions, however, it's not unusual for only one of them to be raised in a particular case. Subsection A rewords the statute to make it clear that the examination may evaluate the defendant's competency or the defendant's sanity, or both. In addition, subdivision C1 requires that a copy of the examination report be provided to the Commissioner of Mental Health. Subsection Division C2 addresses those cases where issues regarding both the defendant's sanity and the defendant's competency have been raised, and the psychiatrist or psychologist conducting the examination has been asked to provide an opinion as to each one. In these cases, subdivision C2 requires an examination of the defendant's sanity only be undertaken if the defendant is first found competent to stand trial. Section 2 concerns the court proceeding that existing law requires after a defendant has been found to be either insane at the time of the offense or incompetent to stand trial. After such a finding, the court holds a hearing to determine whether the person is a danger to self or others. If the person is a danger, he or she must be committed to the Department of Mental Health for treatment. Currently, the person's criminal defense counsel continues to represent the person at the hearing. Section 2 instead provides that the defendant is entitled to have counsel appointed from the Vermont Legal Aid. A defendant who would prefer to be represented by a private attorney can still choose to do so. Section 2 also provides that the Department of Mental Health is entitled to appear at the proceeding and call witnesses. If the court does not find the defendant a danger to self or others and commits him or her to the Department of Mental Health custody for treatment, current law provides no way for the crime victim to be made aware when the person returns to the community. Section 3 closes that gap in victim safety by creating a comprehensive system of victim notification in these cases. And this system is even more robust than it was in S183 last year. Under Section 3, the victim notification requirement applies if a defendant has been committed to the Department of Mental Health custody after either 1, having been found not guilty by reason of insanity, or 2, having been found incompetent to stand trial. If the criminal case has not been dismissed, notification is not required if the criminal case has been dismissed, because these are typically minor matters such as shoplifting, where notice to victim is not necessary. When it is required, the Commissioner of Mental Health must provide it within one of three circumstances occurs: 10 days before the person is discharged from the Department of Mental Health custody, or 10 days before the person is discharged to the community on an order of non-hospitalization, known as an ONH. So notice is required if the person is completely discharged from the Department of Mental Health custody, or if the person is receiving treatment in the community on an ONH while still under Department of Mental Health custody. Second, notice is required at least 10 days prior to the expiration of a commitment order if the Commissioner decides not to seek continued treatment of the person. This ensures that notice is provided even when there's not been a formal discharge if the person will be returning to the community. And finally, notice is required anytime the person absconds from Department of Mental Health custody. If notice action is required, the Commissioner must notify the state's attorney in the county where the prosecution originated, or the Attorney General if that office prosecuted the case. The state's attorney or Attorney General must then provide notice of the action to any victim of the offense who is not opted out of receiving notice. Lastly, Section 3 has a separate notice provision that applies when the committed person is in the community on an order of non-hospitalization. If the person is not complying with that order, or if the treatment has not been adequate to meet the person's needs, the Commission must provide notice about the situation to the court that made the commitment to the state's attorney of the county where the prosecution originated, or to the Attorney General if that office prosecuted the case. When a defendant provides notice that sanity is an issue in the case, the Vermont Rules of Criminal Procedure 16.1 permits the prosecution to have its own psychiatrist or other expert conduct a reasonable mental examination of the defendant. However, the rule does not permit the prosecution to conduct its own exam when the defendant's competency is at issue. Section 4 does so, adding new language that permits the prosecution to have its own psychiatrist examine the defendant when the court-ordered examiner has found the defendant incompetent to stand trial. The Judiciary Committee is aware that this provision is likely to be litigated because the offices of the Attorney General and Defendant General have different views about whether this change infringes on a defendant's constitutional right against self-incrimination. Section 5 requires the Department of Corrections and Mental Health to jointly submit to the General Assembly an inventory and evaluation of those mental health services provided by the entity the DOC contracts with for healthcare services. Specifically, the two departments are required to compare how the type, frequency, and timeliness of mental health services provided in the corrections arena differ from those services available in the community. The results of the work are due by November 1st of this year, and I might add, Madam President, that this section is extremely important in understanding that many people with mental health issues are held longer on bail conditions or held without bail longer than the average population in a jail. And that's both the Vermont statistic as well as the national statistic. Section 6 establishes a forensic care working group. It requires the Commissioner of Mental Health to convene a working group of specific stakeholders, including crime victims, to address two issues regarding Vermont's forensic population. First, identify gaps in the mental health and criminal justice structure and opportunities to improve both public safety and the coordination of persons incompetent to stand trial and adjudicated not guilty by reason of insanity. Specifically, the working group will review models used in other states, such as psychiatric security review boards, competency restoration models, and guilty but mentally ill verdicts in criminal cases. Second, the Commission would evaluate models for the creation of state-funded forensic treatment facility, taking into account of the beds needed, if any, operating cost, which entity would be the best to operate such a facility and whether an existing facility could be repurposed. The Department of Mental Health is required to submit a report on any proposed legislation based on the working group's recommendations to the Joint Justice Legislative Oversight Committee by November 1, 2021. Section 7 appropriates funds to the Department of Mental Health and the Vermont Legal Aid to provide legal representation and evaluations in commitment proceedings. These funds are necessary because Section 2 both expands legal aid and Department of Mental Health responsibilities and participation in these proceedings. Section 8 provides that the bill takes effect on January 1, 2021. Madam President, your Judiciary Committee heard from a large group of witnesses, including Karen Barber, General Counsel, Department of Mental Health, Kelly Carroll, impacted citizen from Bennington, Eric Fitzpatrick, Legislative Counsel, Morning Fox, Deputy Commissioner, Department of Mental Health, Brian Grierson, Chief Superior Judge, Erica Mathid, State's Attorney, Bennington County, Jack McCullough, Director of Mental Health Law Project, Katie McKinn, Legislative Counsel, James Pepper, Deputy State's Attorney, Department of State's Attorneys in Sarah Robinson, Deputy Director, Vermont Network Against Domestic and Sexual Violence, David Shearer, Assistant Attorney General, and Matthew Valerio, Defender General. Madam President, the vote in committee was 5-0-0, and we ask for the Senate's concurrence.
Thank you, Senator. The senator from Bennington is further recognized for the report of the Committee on Appropriations.
Well, Madam President, as often happens, the Appropriations Committee has decided to remove two of the appropriations, the appropriation to the Department of Mental Health and the appropriation to the Vermont Legal Aid, each with $250,000. So that sum will be put aside and considered as part of the big bill. They did, however, approve the Appropriations Committee, however, Madam President, approves the forensic working group's payment for those who are not state employees and not otherwise reimbursed, but members of that working in Section 6. So Appropriations recommends on a 7-0-0 vote to remove $500,000.
Thank you, Senator. The question is, shall the Senate amend the Judiciary report as recommended by the Committee on Appropriations? Are you ready for the question? Please unmute. Again, the question is, shall the Senate amend the Judiciary report as recommended by the Committee on Appropriations? All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've amended the report as recommended by the Committee on Appropriations. The senator from Bennington is further recognized for his amendment.
Madam President, this amendment is supported by the Senate Judiciary Committee and is an amendment to Section 6 that would have part of the study look at issues regarding notification to the prosecutor upon becoming aware that the person on orders of non-hospitalization and not complying with that order or the alternative treatment is not adequate, so that the working group would make recommendations to clarify the process, including recommendations to what facts and circumstances should trigger the commissioner's duty to notify the prosecutor, and recommendations as to the step that the prosecutor should take after receiving that notification. So this is related to the Section 3 process, and it would be studied by the forensic working group.
The question is, shall the Senate amend the report of the Committee on Judiciary as recommended by the senator from Bennington? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
Aye.
Aye. Those opposed, nay. The ayes have it, and you've amended the report of the Committee on Judiciary as recommended by the Senator of Bennington. The question now is, shall the Senate amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? And if so, please unmute. The Senator from Addison is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill, please?
You may.
Thank you. I'm curious about your comment regarding Section 4 and the language about and how you said that there was a disagreement over the constitutionality of this section, and wondered if you could expand on that and the committee's decision to leave it in and what it means for this provision. I'm sorry, Senator, you're muted.
This is disclosure to the prosecution, and the argument between the prosecutor, in this case, the Attorney General's office, and the Defender General was one of whether or not it was constitutional. The Committee on Judiciary felt that it would be ruled constitutional, and then so we favored keeping the section in, but I wanted to make sure that we were as transparent as possible and that there was a disagreement between the two on the section.
Okay, I'm sorry, Madam President. You were a little bit hard to hear. You said that you felt like the committee felt that it would be constitutional. Yes, be constitutional.
Yes.
Okay.
Yes, we felt it would be, but as you know, Madam President, you can't go down the street to the Supreme Court and ask whether it is or not. And so we, in order to be fully transparent, I felt it was important.
Okay. Thank you, Madam President.
Within the report that there was this disagreement on Section 4 between the two. But we feel strongly that it is, that the a reasonable mental examination by a psychiatrist or other expert when a court order examiner pursuant to reports that a defendant is not competent to stand trial gives the state an opportunity.
Okay. Thank you, Madam President. Thank you for that clarification.
The question is, shall the Senate amend the bill as recommended by the Committee on Judiciary as amended? Are you ready for the question? And if so, please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Judiciary as amended. The question now is, shall the bill be read the third time? Are you ready for the question? The Senator from Windham is recognized.
Thank you, Madam President. May I inquire of the reporter, please?
You may.
Thank you. Madam President, looking at Section 6 in relation to the Forensic Care Working Group, I'm wondering, Madam President, whether you have, whether you took testimony on the approximate size of the population that would be treated in a forensic treatment facility here in Vermont. I know this has been a topic of much discussion as of late, and I'm just wondering if you took testimony on that particular aspect.
I don't believe we did this year, but last year, my recollection, and I could stand to be corrected by the senior senator from Windham, who worked on this bill along with the rest of the committee last year. I believe there was discussion of 6 to 8 people.
Thank you. Thank you, Madam President.
The question is, shall the Senate amend the bill, or sorry, the question is, shall the bill be read a third time? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've ordered third reading of S3. We have on the calendar for action S97, introduced on February 26th. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the bill be amended as appears on pages 708 to 714 of today's calendar, and that when so amended, the bill ought to pass. The bill was further referred to the Committee on Finance, which reports that the bill should be amended as recommended by the Committee on Judiciary, and that when so amended, the bill ought to pass. Please listen to the second reading of S97.
S97, an act relating to miscellaneous judiciary procedures.
The senator from Windsor, Senator Nitka, is recognized for the report of the Committee on Judiciary.
Madam President, this bill proposes several minor amendments related to judiciary procedures. Section 1 repeals the sunset on changes to the diversion program that were made in 2017. This repeal passed the Senate in S-234 last year, but during the COVID emergency, it was decided that several sunsets would simply be extended by 1 year rather than repealed entirely. These changes are now scheduled to sunset on July 1, 2021, which is why they are being dealt with again this year. The two most significant changes made in 2017 were expanding diversion to include adults with substance abuse or mental health treatment needs, regardless of the person's prior criminal history record. Adult diversion had only been available to persons previously charged with a first or second misdemeanor or a first nonviolent felony. And 2, requiring that for certain crimes, the prosecutor must provide the offender with the opportunity to participate in diversion unless the prosecutor states on the record at arraignment or a subsequent court hearing why doing so would not serve the ends of justice. Section 1 repeals the sunset and makes these changes permanent. Section 2 extends the sunset on the racial disparities in the Criminal and Juvenile System Advisory Panel, RDAP. This repeal also passed the Senate in S-234 last year, but was also ultimately extended by only 1 year until July 1, 2021, which is when the sunset is now scheduled to occur. RDAP reviews and provides recommendations to address systemic racial disparities in statewide systems of criminal and juvenile justice. Section 2 repeals the sunset and makes the Racial Disparities Advisory Panel permanent. Section 3 repeals the sunset on spousal maintenance and support guidelines. This passed the Senate in S-99 last year, but the bill was not taken up in the House. The court and litigants agree that the guidelines are working well and should be made permanent, so Section 3 repeals the sunset. Section 4 extends the sunset for the Vermont Sentencing Commission from July 1, 2021 to July 1, 2022. The commission still has work to do, particularly regarding its proposal to establish a classification system for all crimes, so Section 4 gives them another year to complete it. Section 5 was requested by the Attorney General's Office and repeals 13 VSA 2579, which allows civil actions based on the crime of retail theft. The statute was enacted before restitution was created to provide a much better method to make retailers whole after a theft. With restitution available, the statute is no longer needed. Section 6 was requested by the courts and repeals 20 VSA 187, which requires district judges to designate 3 successors to serve in the judge's place if the judge is incapacitated. The statute dates from the 1950s and has apparently never been used, and the court does not think it ever would be used in the future. Section 7 clarifies the fee for appointing a personal representative to bring a wrongful death action. 14 VSEA 1492A requires the court to appoint a personal representative to bring the action on behalf of the person who died. However, the statute does not specify the fee for the appointment, and probate courts have not been in agreement as to the correct amount. Section 7 resolves this ambiguity by clarifying that the fee is $50, the same entry fee currently set in statutes for estates of less than $10,000. Section 8 clarifies that the filing fee for registering a guardianship order from another state or country with the probate court is $90. This is the amount they had been charging, but it wasn't in the statute. Section 9 makes 2 amendments to the jurisdiction of the Judicial Bureau. The first, in subsection 7, corrects the cross-reference to hazing cases because they were relocated to a different chapter of law. The second deletes subsection 19 entirely because the process referred to, obtaining the Vermont seal of quality for agricultural products, has been repealed and no longer exists. Section 10, 11, and 12 are necessary to correct an error made when the 2019 Transportation Bill and the 2020 Cannabis Tax and Regulate Bill, Act 164, both made amendments to the same statutes regarding blood draws for the purpose of determining the presence of alcohol or other drugs. The 2019 Transportation Bill specified that a blood draw for purposes of determining the presence of alcohol or another drug can only happen, quotes, at a medical facility, police, or fire department, or other safe and clean location as determined by the individual withdrawing the blood, end of quotes. And 2, prohibited law enforcement officers from conducting the blood draw. The Senate Judiciary Committee specifically made these changes to the Senate Transportation Committee's proposal for the 2019 Transportation Bill. The language passed and it is currently in effect. However, given how long it took to pass Act 164, that's the 2020 Cannabis Tax and Regulate Bill, this language did not make it into the final version of that act. As a result, the language will be repealed when Act 164, Section 24, goes into effect on January 1, 2022. Since this was an oversight, Sections 10, 11, and 12 correct the error and make the blood draw provisions permanent, just as the legislature originally intended. Finally, the bill takes effect, except that the Act 164 correction takes effect on January 1, 2022, the same day that Act 164 itself takes effect. Persons testifying were Dr. Etan Nasreddin Longo, the chair of the Racial Disparities Advisory Panel, David Scher of the Attorney General's Office, Eric Fitzpatrick, our legislative counsel, and James Pepper of the Sheriff's and State's Attorney's Office. The vote in the committee was 4-0-1, and we request your support. Thank you, Madam President.
Thank you, Senator. The senator from Chittenden, Senator Sirotkin, is recognized for the report of the Committee on Finance. Senator, kindly unmute. The senator from Chittenden, Senator Sirotkin, is recognized, and there we go.
Thank you. Thank you, Madam President. Senate Finance reviewed Section 8 and 9 of the bill, which was found on page 711 of the calendar, of today's calendar, as was expressed by the senator from Windsor. There are 2 fees in this bill, both dealing with the probate court and trying to bring some clarity and uniformity to those fees. She accurately described the problems that with these fees, and we've established the fee for a personal representative for a wrongful death action at $50 and establishing or registering a foreign guardianship at $90. The vote in our committee was 7-0. We heard from Legislative Counsel Eric Fitzpatrick and the Chief Administrative Judge, Brian Grierson, and who explained to us that there were very few of each of these filings that exist right now, but there needed to be some uniformity throughout the state. Thank you.
Thank you. The first question is, shall the Senate amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
Aye.
Aye. Those opposed, nay. The ayes have it, and you've amended the bill as recommended by the Committee on Judiciary. The question now is, shall the bill be read the 3rd time? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
Aye.
Aye. Those opposed, nay. The ayes have it, and you've ordered 3rd reading of S97. There has been a request to pass over S60. So without objection, we'll now pass over S60 and move to S88. We have on the calendar for third reading S88. Third reading was ordered on March 19th, 2021. Are there any amendments before third reading? Please listen to the third reading of the bill.
S88, an act relating to insurance, banking, and securities.
The question now is, shall the bill pass? Are you ready for the question? Please unmute. All those in favor, please signify by saying aye.
Aye.
Those opposed, nay. The ayes have it, and you've passed S88. We have on the calendar for third reading S114. Third reading was ordered on March 19, 2021. Are there any amendments before third reading? Please listen to the third reading of the bill.
S114, an act relating to improving pre-kindergarten through grade 12 literacy within the state.
The question now is, shall the bill pass? Are you ready for the question? All those in favor, please unmute and signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've ordered passage of S114. There's been a request to pass over H315. Without objection, we will now pass over H315. We have on the calendar for second reading S51, which was introduced on January 28th. It was referred to the Committee on Government Operations, which reports as considered the bill and recommends that the bill be amended as appears on pages 715 to 717 of today's calendar, and that when so amended, the bill ought to pass. I'll come back to it, John. The bill was then referred to the Committee on Appropriations, which reports that the bill should be amended as recommended by the Committee on Government Operations, and that when so amended, the bill ought to pass. Please listen to the second reading of the bill.
S51, an act relating to the persons authorized to make contributions to candidates and political parties and to political committee names.
The senator from Washington, Senator Polina, is recognized for a report of the Committee on Government Operations.
Thank you, Madam President. S51 may seem familiar to many of us. It's the bill that the Senate passed last year, and it's got hung up in the other chamber. The bill S51 does three things. It requires PACs to better identify themselves. It defines who can contribute to political candidates and political parties. And it establishes a study of our state campaign public financing system. Section 1 refines the definition of a political action committee, says that they can register with the Secretary of State office before they reach the traditional threshold of raising or spending $1,000. Section 2, in a move towards greater transparency, requires political action committees, PACs, to include in their name the full name of its connected organization or any clearly recognized abbreviation or acronym by which the connected organization is commonly known. Now, a connected organization relative to a PAC would be a committee, a corporation, a labor organization, a public interest group, or other entity that directly or indirectly establishes, administers, or financially supports the PAC. What that means is that, for example, if Monsanto starts a PAC, they can't call it Neighbors for a Clean Environment. They must call it Monsanto Neighbors for a Clean Environment. So the idea is to get them to better identify the organizations, the connected organizations that are supporting, establishing, or administrating a PAC. Section 3 defines who can provide campaign contributions to political candidates and political parties. It says that only individual persons, PACs, and political parties can contribute to a candidate or to a political party. Section 3 also states that a candidate or political party shall not accept a contribution from any person other than those permitted to make such a contribution under this section. It does clarify that an individual can make a contribution to an unincorporated, it clarifies that an individual can make a contribution as an unincorporated sole proprietorship or from his or her revocable trust. Now, you'll notice that corporations are not included in those entities allowed to contribute to candidates and parties cannot accept contributions from them. This prohibition on corporate contributions is something over 20 other states have done. The federal government did it about 100 years ago, a little more than 100 years ago. It has been upheld by the courts, and as mentioned, this body voted in favor of it last year. Finally, in Section 4, the bill establishes a public campaign finance study. I'll remind you that Vermont has a public financing option for governor and lieutenant governor, but it is rarely used because it's really just not user-friendly. So this study will look at how public financing works in other places, for example, Maine, Connecticut, Arizona, Seattle, New York City, to determine what changes, if any, we should make to our system and even whether we should abolish the system of itself. The study committee will be made up of 2 legislators, a representative from Secretary of State's office, the Attorney General or representative, the Director of the Ethics Commission or representative. The legislators shall be reimbursed for 5 meetings. So in a nutshell, what the bill does is it requires PACs to better identify themselves by using in their name the name of an organization that is connected to them and supports them, administers them, or establishes them. It then goes on to say who can provide contributions to political candidates and parties, and that means individuals, PACs, and parties. And then it sets up a study committee to look at problems that we have with our public financing system in Vermont. Many other states have public financing systems that work quite well. In Connecticut, about 85% of their legislators rely on public financing to win their elections. The committee vote was 4-1-0, and we ask you to support us and join us in supporting S51.
Thank you, Senator.
I would say that we heard from Amajan Abrajali, Legislative Counsel, Deborah Bilodeau, Chair of the Vermont Republican Party, Paul Burns, the Executive Director of the Vermont Public Interest Research Group, and Will Senning, Director of Elections and Campaign Finance for the Secretary of State's Office, and Chris Winters, Deputy Secretary of State's Office.
Thank you, Senator. The Senator from Essex Orleans, Senator Starr, is recognized for the report of the Committee on Appropriations.
Yes, thank you, Madam President. Appropriations did look over the requests from government ops in regards to the 5 meetings and the cost of those 5 meetings, and found that there was no adverse effect on the cost to the state of Vermont. These funds would be extracted from our legislative summer study committee meetings. We also we heard from the Government Operations Committee, Senator Polina. And our committee vote was 6-1-0, and recommend that the bill be passed. Thank you.
Thank you. The question is, shall the Senate amend the bill as recommended by the Committee on Government Operations? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay.
No. No.
The ayes appear to have it. The ayes do have it, and you've amended the bill as recommended by the Committee on Government Operations. The question now is, shall the bill be read for the 3rd time? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
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 Aye. Aye.
Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it. You've ordered 3rd reading of S51. We will now take up S66. We have on the calendar for action S66, which was introduced on February 5th, 2021. It was referred to the Committee on Transportation, which reports it has considered the bill and recommends that the bill ought to pass. The bill was then referred to the Committee on Finance, which also reports that it's considered the bill and recommends the bill ought to pass. Please listen to the second reading of S66.
S66, an act relating to electric bicycles.
The senator from Chittenden, Senator Chittenden, is recognized for a report of the Committee on Transportation.
Thank you, Madam President. This bill aims to make clear to our municipalities, our retailers, and Vermonters what an e-bike is and what it isn't, so that our rules at the state and local level can be consistent with the already adopted federal and international manufacturing and product safety standards that define classes of pedal assist bicycles. Currently, the lack of state standards for these emerging and increasingly common devices opens the doors for conflicting or inconsistent regulations across our municipalities that maintain segments of the same road and recreation networks, and it makes it more difficult to keep our roadways and bicycle lanes safe. 28 states across our country have currently defined and regulate 3 classes of e-bikes. S66 adopts this same 3-class system in Vermont and aligns our state statutes with the federal and manufacturing product safety standards already in effect. This bill also provides clarity enabling local regulation of e-bikes so that our towns and cities can set their own rules using the same international, federal, and with this bill, state terminology and classifications. A uniform labeling standard for all e-bikes will also help law enforcement and public safety officials easily identify the class of electric bicycles in the event of enforcement issues. As for the bill sections, Section 1 clarifies that e-bikes are not motorcycles. Section 2 clarifies that e-bikes are not motor vehicles. Sent out this morning via email to all senators was a 1-page visual. Really, that was helpful for me in taking testimony on this bill to clarify what we're discussing when we are using this term electric bicycles or e-bikes. Section 3 clarifies that e-bikes are not motor-driven cycles and clarifies that motor-driven cycles are unique in that they have an internal combustion motor. Section 4 defines electric bicycle as a bicycle equipped with fully operable pedals, a key distinction, as well as a saddle and a seat for the rider, and an electric motor of less than 750 watts that fits within 3 classes, which are further defined. Class 1 e-bikes are bicycles that are ped assist, meaning that the rider must be pedaling for the motor to engage. They have a top speed of 20 miles per hour. Class 2 e-bikes are throttle assist, meaning the motor can provide power independently of whether the rider is pedaling. As with Class 1 e-bikes, Class 2 also have a top speed of 20 miles per hour. Class 3 e-bikes are pedal assist bikes but have a top speed of 28 miles per hour. 28 because then kilometers, that's 45 kilometers per hour, and we are trying to synchronize with our friends across the pond through the international standards that are in effect. Section 5 adds e-bikes riders to the definition of vulnerable user. Section 6 provides that e-bikes are regulated as bicycles under Vermont law and that the same rules of the road apply to both e-bikes and human-powered bicycles when it comes to speed, proper passing, local traffic laws, speed limits, equipment, and other ordinances. Section 6 also clarifies that e-bikes are not subject to registration, licensing, or insurance requirements that apply to motor vehicles. Section 6 also requires that e-bikes comply with equipment and manufacturing requirements for bicycles promulgated by the U.S. Consumer Product and Safety Commission. It requires the Class 3 e-bikes to be equipped with a speedometer. And this section also deals with the municipal regulation of e-bikes. Under the bill, following proper notice and public hearing, municipalities and local authorities and state agencies with jurisdiction over bicycle and multi-use paths may prohibit the operation of Class 1 and Class 2 e-bikes on paths if they find such a restriction is needed for safety reasons or compliance with other laws or obligations. S66 also allows those entities to prohibit the operation of the Class 3 e-bikes without a public hearing. So it gives them additional powers. The bill does not regulate the use of electric bicycles on trails where land management agencies maintain their authority to regulate. Section 6 specifically provides that such authority rests with the applicable land management agency. Finally, Section 6 prohibits individuals under the age of 16 from operating a Class 3 e-bike. Those under 16 could ride as passengers on a Class 3 e-bike if the bike is designed to accommodate passengers. There are 3 more sections. I'm almost done. Section 7 requires that manufacturers and distributors of e-bikes to apply a label to each electric bicycle containing the classification number, top assisted speed, and motor wattage. This provision is included to assist with enforcement. Section 7 also prohibits individuals from tampering with or modifying electric bicycles to change the powered speed of the bike. Sections 8 and 9 clarify that e-bikes are not all-terrain vehicles. Section 10, the last section, includes the effective dates. The bill would go into effect on July 1st, 2021, except for the labeling requirements, which would take effect on January 1, 2022. The committee heard from Senator Brian Campion, the sponsor, Paul Connor, the Director of Planning and Zoning of South Burlington, and Thea Dexter Cooper, Legislative Counsel, Alex Lodgman, Policy Counsel, People for Bikes, Dylan Zwicky, Lobbyist of People for Bikes Legislative Council. We also indirectly heard via email from the Vermont League of Cities and Towns, where they expressed to us that they have no concern with the legislation. Your Transportation Committee voted favorably, 5-0-0, and we ask the Senate to concur. Thank you, Madam President.
Thank you. The senator from Chittenden, Senator Pearson, is further recognized for the report of the Committee on Finance.
Thank you, Madam President. This bill, as you've just heard, came to finance because it clarifies there are no fees associated with e-bikes. We are treating them just like bicycles, and the Committee on Finance supported that and voted to recommend unanimously. Thank you.
Thank you. The question is, shall the bill be read the third time? Are you ready for the question? If so, please unmute.
Madam President.
The senator from Bennington is recognized.
Thanks, Madam President. On behalf of Senator Westman, who's the co-sponsor, and I just want to thank the Committee on Transportation, particularly Senator Chittenden, for his floor report. We're hoping that this will expand use of e-bikes throughout the state, and I think this is an important and very positive next step. So thank you.
The question is, shall the bill be read the third time? Are you ready for the question? All those in favor, please unmute and signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've ordered third reading of S66. We'll now move forward to S62. We have on the calendar for action S62, which was introduced on February 3rd. It was referred to the Committee on Economic Development, Housing, and General Affairs, which reports it has considered the bill and recommends that the bill be amended as appears on pages 717 to 721 of today's calendar, and that when so amended, the bill ought to pass. The bill was further referred to the Committee on Appropriations, which reports that the bill should be amended as recommended by the Committee on Government Operations, and that when so amended, the bill ought to pass. Please listen to the second reading of S62.
S62, an act relating to creating a new Vermont employee incentive program.
The senator from Franklin, Senator Brock, is recognized for the report of the Committee on Economic Development, Housing, and General Affairs.
Thank you, Madam President. This bill consolidates two programs that exist in statute, and they are incentive programs intended to recruit new workers into the state. The first was the New Worker Grant Program, which was created in 2018, and that was for remote workers, meaning workers who were working in Vermont and moving to Vermont to live and work from here for companies located outside the state of Vermont. It was expanded to the additional second program, which was a New Worker Relocation Incentive Program, which was created in 2019. And that program was designed to recruit new people to come to Vermont to work in jobs that exist in Vermont for Vermont employers. What this bill does is it consolidates the two programs into a single program. As we look back at the results of these programs were originally designed with a recognition that we had a problem here in Vermont. We didn't have enough workers. Employers were struggling quite often to find people to fill jobs in Vermont. And we also recognized that we needed to have new jobs in Vermont particularly that would be filled with people who were not necessarily from here. And by what I say new jobs, I mean jobs that actually were being done elsewhere. This was a mechanism to increase our tax revenues and our tax revenues from outside the state. As we look at what's happened over the past 2 years that these laws have been in effect, we've brought into Vermont 284 new tax-paying households into Vermont. These households represent 638 new Vermonters, including 117 children. And among the things that we considered when these bills were adopted is not only creating new tax revenue, and tax revenue from a variety of sources, the income tax, the sales tax, other consumption taxes, real estate taxes, and the like. We also recognized that by bringing new children in, we were filling some of the seats in Vermont schools that have been lost to the fall in students that's occurred over the past 20 plus years. Of the new worker program grantees thus far who've shared their household income, the average household income is $96,780. And although the programs, depending upon when they were enacted, allowed for grants to new workers ranging up to $10,000, the grants actually, in terms of average for remote workers, was $3,571, and for new workers, relocating workers, was $4,605. We've granted thus far to date $1,063 and $1,063,108. Now, there are very few programs, and one of the things that struck me about this program is I'm hard-pressed to find a program that we institute in Vermont that makes a profit to the state in the first year. And this program does that and has done that. We brought in terms of the new people who came in under this program, they represent $27 million in income, $1 million in income tax revenues, and an additional $2 million for other state tax revenues. We also brought people to Vermont from elsewhere, and the range of people who came to Vermont were from all over the country. And they relocated not just to one location in Vermont, but to communities large and small throughout the entire state. As an example, as we look at people who come into Vermont, we can see that they have come from Washington, California, Nevada, Colorado, Texas, Alabama, Minnesota, New York, Pennsylvania, all over the country. And they've come for a variety of reasons, but one of the principal reasons is that Vermont's a safe place. It's a safe place to be. By advertising this program, we received, just by creating this program, we received more than $7 million in print and television advertising, which advertised Vermont as a good place, a safe place, a wonderful place to come and raise a family. And it's that kind of advertising, which a relatively small investment in creating this program managed to generate. When the program was created, the department looked, for example, at how other states were creating jobs within their state. And we looked at things like, if you recall, when New York tried to get an Amazon facility in New York City, they were spending approximately $250,000 a job for that, and it didn't happen. When some states in the South were recruiting automobile factories, they were spending upwards again of $225,000, in one case over $300,000 a job. We did this for about $3,500 a job in bringing people here to fill desperately needed jobs in the case of the relocating worker, and to bring new jobs that didn't exist before as far as the remote worker program is concerned. If we look at the bill itself in a section-by-section summary, Section 1 states the intent and purpose, which is to expand the Vermont workforce, attract new residents to the state, and provide support to employers who are unable to fill positions from among candidates already located in the state, whether that's due to our very low unemployment rate or due to a disconnect between job requirements and candidate qualifications. And we were careful in crafting this particular legislation to ensure that we are not competing with employees who are already here and who are unemployed. We're only looking for jobs which we and employers are unable to fill. And in particular, if we look at job classifications such as nurses and other medical professionals and a variety of other positions which we simply have not been able to fill. At the time these laws were first created, Vermont had the lowest in the nation unemployment rate of about a little over 2%. We're now down to an unemployment rate of about 3%, although the workforce has dropped somewhat. But we still are about the lowest or second lowest in terms of unemployment rate in the nation. And employers are still indicating very loudly that there are lots of jobs that they're unable to fill. Section 2 of the bill codifies in state a new program to be named, designed, and implemented by the Agency of Commerce and Community Development to award incentive grants to relocating employees. The grant maximum is now $5,000, lower than it was in some of our earlier programs, with an enhanced grant maximum of $7,500 for a relocating employee who becomes a resident in a Vermont labor market where the average annual unemployment rate in the labor market exceeds the annual unemployment rate in the state, or where the annual average wage in the state exceeds the annual average wage in the labor market area. In Section 1C, the agency will adopt procedures, promote the program, award grants on a first-come, first-served basis after July 1 of 21, and adopt performance metrics. There are some reporting requirements that are similar in nature in terms of timing. Section E defines some terms in terms of what the qualifying expenses are for relocation. They may include moving costs, closing costs of a primary resident, rental security deposit, a month's rent, other relocation expenses established in agency guidelines, and reasonable and necessary costs, including, depending upon the employee's location and position, for example, to upgrade or enhance broadband connectivity or to acquire membership in a co-working or similar space. A relocating employee means a resident who becomes a full-time resident of Vermont of a Vermont location of a business domiciled or authorized to do business in the state. And the employer, again, attests to the agency that after reasonable time and effort, the employer has been unable to fill the employee's position from Vermont applicants. The wage threshold for these jobs is 160% of the state minimum wage or 140% of the minimum wage if the relocating employee is in a labor market area that has these lower wages that we've described before. The individual must be subject to Vermont income tax, and there are a number of transition items regarding funding, and it repeals the existing programs. This takes effect on July 1, 2021. We heard from Joan Goldstein, the Commissioner of the Department of Economic Development, from David Hall, Legislative Counsel, and from Kristen Zeter, the Financial Manager at the Department of Economic Development. The committee vote on this was 5-0-0, and we recommend this to you and ask for your vote. Thank you.
Thank you, Senator. The senator from Chittenden, Senator Baruth, is recognized for the report of the Committee on Appropriations.
Thank you, Madam President. The Committee on Appropriations did go through this bill, and we heard enthusiastic testimony from my colleague from Franklin. We responded to it in the way that we have begun to respond to a number of bills, which is to strike the section with the appropriation and range it with all of the others on the wall for a time when we know the full spectrum of requests and we can judge them one against another. So you'll see that section 5 is struck in its entirety, and then the sections are renumbered with no prejudice against the bill. And in fact, there was discussion of how such a program might be funded down the line. So our committee vote was 7-0-0, and we would ask that the bill be amended as voted. Thank you.
Thank you, Senator. The first question is, shall the report of the Committee on Economic Development, Housing, and General Affairs be amended as recommended by the Committee on Appropriations? Are you ready for the question? The senator from Washington is recognized.
Thank you, Madam President. May I inquire of the speaker or the presenter of the bill?
You may.
Madam President, I was glad to see some added sections here on measurable goals and performance measures in an audit strategy. I was just wondering, though, that the report that's required does not include reporting on the audit strategy. And I wondered what the committee was thinking, if the audit strategy included an audit or included just a strategy. I just wondered if we could hear more about what the committee was thinking about audit strategy of the program.
Sure. Well, we know that the results of any of these programs are subject to the annual audit conducted by the Auditor of Accounts. What we wanted to make sure is, though, that there was sufficient data for an audit or for this to be addressed as part of the department's annual audit. And also that the legislature be aware of the performance metrics for the program. Now, thus far, the department has been producing performance metrics, and we have quite a few of them. There are annual reports that exist right now that discuss how many people have been involved, the number of folks who come to Vermont, a lot of data collection on what their average annual wages are, the number of people who come from their families. We've got information regarding their demographics so that we have an idea of how they affect the state. And then we've collected information as to where they've come from. And also the department has collected information about where they've gone within Vermont. There's information that's collected, again, about prior Vermont experience. One of the things that's always difficult in these programs is to determine, does the program work? Did it, in fact, cause the activity? And we've run into this constantly about economic development programs, ranging from the Veggie program, for example, where we have this but-for clause. And those things are virtually impossible to audit from a quantitative standpoint. But the more information that you have to the results, then you can evaluate carefully those people who are decision makers, as we are here. Does this appear to make sense? We ask people, among things, about what's their prior experience with Vermont. We ask them questions like, what motivated you to take advantage of this particular offer? How did you learn about it? And one of the interesting things about the remote worker program is that 58% of the people said that this incentive program was one of the things that pushed them over the edge that made them decide to come to Vermont. We also noticed a substantial number of the people would not have known necessarily about Vermont and about this opportunity were it not for the publicity generated by this program. And as I mentioned, we got, by creating this program with relatively small amounts of money, we got some $7 million worth of national advertising on everything from CNN to the Wall Street Journal and so on. These things alerted people to the opportunity. And then the department had a number of other programs, the Stay to Stay program, for example, that invites people to come to Vermont to experience it on a weekend and to use that as a mechanism to promote Vermont and the possibility of moving. All of those things are factored. And can you say that any one thing is? I don't think you can. But it's the sum total of all of those efforts that I believe has made for the kind of success that I believe we're seeing here.
Okay. Thank you, Madam Speaker. And I know the Senator from Franklin knows a lot more about auditing than I do, so I feel that the committee felt that was addressed well, but I appreciate that they did add some language this time around to that. So thank you, and I thank the Senator.
The question is, shall the report of the Committee on Economic Development, Housing, and General Affairs be amended as recommended by the Committee on Appropriations? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've amended the report as recommended by the Committee on Appropriations. The question now is, shall the Senate amend the bill as recommended by the Committee on Economic Development, Housing, and General Affairs as amended? Are you ready for the question? The senator from Addison is recognized.
Thank you, Madam President. May I inquire of the reporter of the bill?
You may.
Thank you, Madam President. Madam President, could you let me know, has this pandemic,
Senator
my recollection is that it was ceased. Oops, sorry.
Broadband this morning, if you don't mind just starting from the beginning, thank you.
Yes, my internet was unstable. May I inquire the reporter of the bill?
You may.
Okay, thank you, Madam President. Could you remind me whether this program has been in effect over the past year during the pandemic? My recollection was that, is that correct?
It was suspended during the time of the pandemic, and there were two reasons. Is that one, on the remote worker program, it ran out of money. But secondly, in terms of continuing the program, the staff were in such a situation that of having to respond to other COVID-related matters. We do have a queue of people in line right now who are interested in the program, but it has been suspended, yes.
Okay, that was my recollection. Over the past year, there have been many media reports and anecdotal evidence that many people have moved to Vermont because we are a safe place and because we have effective government that has been responding to the pandemic appropriately, and that we are a safe place to live. And we've seen increases in enrollments in some school districts and increases in that is because we say people were getting paid to come here for their moving expenses. I have great respect for my colleagues on the Senate Economic Development Committee, and I will support this bill, but I am very skeptical of this program. I am appreciative of the fact that the Appropriations Committee removed the appropriation and that there will be further discussion about the program in the context of the full slate of things that this would like to fund. So thank you, Madam President. Just wanted to be on. Thank you.
Thank you, Senator. The question is, shall the Senate amend the bill as recommended by the Committee on Economic Development, Housing, and General Affairs as amended? Are you ready for the question? The senator from Chittenden is recognized.
Thank you, Madam President. I once again would like to commend the Committee on Economic Development, Housing, and General Affairs for their work on the remote worker program and the integration of in-state as well as out-of-state job security for folks. And I do have a question for the reporter of the bill, if I might.
You may.
Thank you, Madam President. Just a question, as you were looking at the data and the draw for Vermont, was there any indication that childcare was a significant issue for some of the families intending to move to Vermont?
It was not listed as one of the top reasons for or factors to consider. And you do bear in mind that when people make decisions like this, they rarely make it on the basis of a single factor. It's the sum total of everything. And so when we take, let's say, the remote worker program, where people certainly do have the most flexibility because they're not working necessarily for an employer located in Vermont, and 83% said access to outdoor recreation and nature. 69% says it's a safe place to live and raise a family. 58% said the remote worker grant program. 44% said friends and family live here. 44% said the quality of education. And 2% said available job opportunities. And that's for the remote worker program. There's similar data for the relocating worker program. But again, obviously, the percentage of available job opportunities in this case jumped to 76%. But the other data was substantially the same. And childcare was not one of the things that was included in the top factors for either group.
Thank you, Madam President. And I find that really very interesting. When I did my initial interview with remote workers several years ago to first introduce the bill, childcare was one of those considerations that people were thinking about. But we will keep that in mind as we go forward and look at our childcare proposals that come to us. But again, I want to say thank you to the Economic Development Committee for the work that they've done on this program and continue to work to do. So thank you, Madam President.
The senator from Essex Orleans is recognized.
Madam President, can I ask a question of the presenter of the bill?
You may.
Madam President, does this bill take every opportunity to consider our Vermont graduating seniors and to offer these positions to these graduating seniors to keep them in state before they strike off to parts unknown? Thank you, Madam President.
I thank the senator. This bill is not focused on new graduates. It is focused on people who are not already here. That's not to say that there aren't programs that are, that are so focused. We spend right now some $50 million a year in 64 different programs administered by the Agency of Commerce and Community Development and others that are focused on all aspects of job training and job retention, and retaining graduates is one of those. This particular program is different.
Thank you, Madam President.
Madam President.
The senator from Rutland is recognized.
Thank you, Madam President. May I interrogate the senator from Franklin?
You may.
Madam President, could the senator tell me if there was any consideration of linking this program to another program that he referred to, the Stay-to-Stay program, and giving some resources to those communities that are utilizing that program? I know that in the past, we've heard from concierge-type programs that are looking for some help to recruit to certain areas of the state. Thank you, Madam President.
Well, there was a discussion about the administrative expenses associated with the program, not necessarily specific about devolving some of that money to local organizations for Stay-to-Stay, but we certainly did hear a lot about the effectiveness of Stay-to-Stay as one of the tools to encourage people to get involved in the program. Generally speaking, when a person or the intake piece of all of these programs is going to the state's particular website that is set up for this program, and there they are introduced to Vermont in general and to things like the Stay-to-Stay program as a mechanism to move to the next step, to be aware of opportunities and to be aware, if they aren't already aware, of Vermont. Now, the people who, who apply, a number of them are aware of Vermont because they've been here for vacation, they've gone to school here, they have other past contacts, they may have relatives here, but there are many who have not had an experience with Vermont, and Stay-to-Stay is one of the ways they get it, and this is a portal to those programs. The funding, though, is not included within this bill.
Thank you, Madam President. I would hope that as we move forward, that there will be some consideration for funding to those individual programs, Stay-to-Stay type programs, that would help us to spread the wealth, as it were, throughout the state, rather than concentrating in areas that people may already be aware of and bringing them to Vermont. Thank you, Madam President.
Thank you. The question is, shall the Senate amend the bill as recommended by the Committee on Economic Development, Housing, and General Affairs as amended? Are you ready for the question? And if so, please unmute. All those in favor, please signify by saying aye.
Aye.
Aye. Aye. Those opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you've amended the bill as recommended by the Committee on Economic Development, Housing, and General Affairs as amended. The question now is, shall the bill be read for the third time? Are you ready for the question? Please unmute. All those in favor, please signify by saying aye.
Aye.
Aye. Aye.
Those opposed, nay.
Nay.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of S62. We have a joint resolution for action. We will now take up JRH5, which was placed in the calendar for action today. This resolution has been read already and is set forth in the journal. The question is, shall the Senate adopt the resolution on its part? Are you ready for the question? So please unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and you've adopted the resolution. This completes the orders of the day. The senator from Windham is recognized.
Thank you, Madam President. This time, I move that the Senate stand in an adjournment until 1 p.m. Wednesday, March 24th.
The senator from Windham has moved that subject to any announcements, the Senate do adjourn until Wednesday, March 24th at 1 p.m. Are there any announcements? The senator from Addison is recognized.
Thank you, Madam President. I'd ask that members of Senate Natural Resources and Energy convene as soon as possible after the fall of the gavel. We have confirmation witnesses waiting. Thank you.
The senior senator from Chittenden is recognized.
Thank you, Madam President. Senate Health and Welfare will meet at 11:15.
The senator from Bennington, Senator Sears, is recognized.
Thank you, Madam President. Senate Judiciary will meet at 11:15. Thank you.
The senator from Bennington, Senator Campion, is recognized.
Thank you, Madam President. Senate Education will meet at 1:30 this afternoon.
Senator from Essex, Orleans, is recognized.
Thank you, Madam President. Senate Ag, 11:15, please.
The senator from Grand Isle is recognized.
Madam President, Transportation, 11:15. Thank you.
The senator from Windham is recognized.
Thank you, Madam President. The Senate Government Operations Committee will meet at 1:30.
Senator, I'm going to kindly ask you to repeat what you just shared. Thank you.
Oh, I'm sorry. Thank you, Madam President. The Senate Government Operations Committee will meet at 1:30.
Thank you. The senator from Chittenden, Senator Sirotkin, is recognized.
Thank you, Madam President. Senate Economic Development will meet at 11:10.
Are there any further announcements? The senator from Windsor is recognized.
Thank you, Madam President. The Senate Democratic Caucus will meet at 12:15. For the public, the link is on the announcements section on the legislative website. Thank you.
Are there any further announcements? The senator from Windham is recognized.
Thank you, Madam President. I would ask that the Chair of Finance, the Chair of Appropriations, and the Chair of Economic Development look for a Zoom link from my office. I want to meet up before Democratic Caucus to discuss the tax link up that Commissioner Bolio requested that we look at. Second thing is just to say this beautiful weather is reminding me of spring training. So we turn our attention to the ball games that hopefully we will all be able to enjoy, not just over the television this summer, but perhaps in person. I'm thinking about a quote from Babe Ruth, who said, "Every strike brings me closer to the next home run." Thank you, Madam President.
Thank you, Senator. The senator from Windham has moved that the Senate adjourn until Wednesday, March 24th at 1 p.m. Are you ready for the question? And if so, please unmute. All those in favor, please signify by saying aye.
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 Those opposed, nay. The ayes have it, and the Senate stands adjourned until Wednesday, March 24th.